Lisa Pratt.
I am.
And Ms. Pratt, this is your initial appearance in cause number 24, DCCR.
All right, folks, here we go. Lisa Pratt is in the hot seat, facing a felony theft charge with prior convictions already on her record. But here's the twist. She's currently out on bond. Now, the judge is making it crystal clear she's expected to hire an attorney, or there will be consequences. Sounds like a routine check-in, right?
60, you're charged with the state jail felony offense of theft with previous convictions, and that's from April 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
They assigned me a lawyer.
They did. So when you're in custody, we give you a court-appointed attorney, but now that you've bonded out, what I do is expect you to at least try to hire your own. So I'm going to reset your case for about 30 days to give you some time to try to hire someone. Okay. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me back the names of the lawyers that you've talked to, so I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand?
Yes, sir.
And are you working?
I'm on disability.
You are? If I test you this morning, you can have anything in your system?
I do. No.
Have a seat in the jury box.
Not quite. Watch how fast this court session turns as the judge makes it known that bond freedom comes with strict conditions. One wrong move, and that freedom could disappear just as quickly as it was granted. Catch that pivot? The judge casually slides in a drug test warning. If I test you this morning, that's legal speak for, I'm suspicious. And in a courtroom, suspicion isn't just a vibe. It can quickly turn into evidence. It's a subtle move, but a powerful one. Is the judge reading between the lines here, picking up on something the rest of us missed? Or is this just a tactic to keep everyone on their toes? Either way, it sets the tone. And now we shift focus to Zachary Turner, who's facing his own serious charge.
Double check what you got in there. Have a seat in the jury box. Good morning, ma'am. You're Precious Eaglin. And Ms. Eaglin, you are here on 2 cases, initial appearance. In cause number 25, DCCR 0317, you're charged with the second-degree felony offense of assault on a peace officer. And in cause number 25, DCCR 0318, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I spoke with Mr. Burbank, but I haven't officially hired him because I'm talking to somebody else.
Okay.
It's like the amount you want as well, so I'm need to call somebody else to see.
Okay, so what I'll do is give you about a 30-day reset to either get Mr. Burbank or someone else hired. If you get someone hired, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes,
if you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to when you come back so I know you're trying. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you that reset notice. Good morning, sir. You're Zachary Turner.
Yes, ma'am.
And Mr. Turner, this is your initial appearance in cause number 24, DCCR 2197. You're charged with the first-degree felony offense of fraudulent use or possession of identifying information, and that is from April 22nd of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay. Looks like you also have prior felony convictions, so it's going to be very important that you try to get someone hired. What you're charged with is extremely serious, obviously. So what I'm going to do, Mr. Turner, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front.
Zachary Turner is facing a first-degree felony for ID fraud, and that's on top of prior felony convictions. He's stacking prison time like it's Jenga. But this isn't some low-level case. The judge isn't just offering legal advice here, she's waving a red flag. This isn't traffic court, this is serious business. A first-degree felony in Texas carries 5 to 99 years behind bars. Feel the urgency now?
Good morning, sir. You are Trishad Tarrant, and Mr. Tarrant is charged with capital murder of a person in a prison. Mr. Brewer, Ms. Jordan, where are we and what's the announcement?
Your Honor, the state is announcing ready. We have no pretrial at this time. I believe I have offered a formal plea offer to the defense.
And she has, that offer has been forwarded to my client. To me at this time, to say that we will probably set this back to trial. If we could, perhaps February next year, just move on.
Well, it'll be when it'll be. But what I do want you guys to do, if there's a formal offer, I'd like to get a formal rejection of that. I have those forms on the tablets. We can get, maybe Mr. Rojas or Mr. Parker can help you fill out that formal. If you don't want to accept a plea agreement, I'll go through that today. Once we do a rejection, the case is placed on the trial docket. Typically, I don't accept that same plea agreement. You can plea open to the court. It could be something different unless there's new information that either of you get between now and then.
It's real. And just when you think it can't escalate any further, the words capital murder enter the picture. This courtroom just took a sharp turn into high-stakes territory. Now the stakes couldn't be higher. We're talking life or even death. The defendant has been offered a plea deal, and here's the catch. Once it hits the trial docket, that offer disappears. Judges don't play games when it comes to murder trials. If you reject the deal now, you better come to trial fully prepared, because there's no turning back.
Once it goes on the trial docket, it'll be expected to go to trial, or it'll be something different because of some information that you guys received. So I'll hold it. If you want to grab one of those tablets. Mr. Rojas, would you mind helping? Thank you very much, sir. And as soon as you do that, I'll go through all of that, bring you back up, and then we'll get it set for trial and look at kind of everybody's, how long we think that might take, and then we'll schedule it around that. But we're definitely not anywhere close to looking into February. We're looking at this year probably, based on our unless there's some big reasons. But we'll see where we get. Okay.
Okay.
All right. I'll hold it while y'all get that taken care of. Good morning, sir. You're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation. Motion to revoke has been filed. What's the announcement?
Your Honor, if the court would entertain going through the motion with you, please, and then I'll get it updated pretty soon.
There's no agreement.
No, Your Honor.
Mr. Mays, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And will he waive the formal reading of the motion?
So late.
Mr. Mays, in cause number 20-36100, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 13th of 2021 for burglary of a habitation, and that was a 3-year deferred probation. Is that correct? So it alleges in that probation, or in that motion, that you violated your conditions of probation. Count 1 alleges that you failed to report to the probation department as required for the months of October and December of 2024 and January of 2025. And is that true or not true? Count 2 alleges that you failed to provide verification of participating in the GED program. Is that true? Just today it's just true or not true, and then we'll get explanations later. It's not true, okay. Count 3 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, that MRT program. Is that true or not true? And count 4 alleges that you're behind in your court-assessed fees. As of January 15th of 2025, you were $3,685 behind. Is that true or not true? All right. Did you enter your pleas of true to counts 1 and 4 freely and voluntarily?
Would you roll those dice? And in another turn, probation just got revoked, not for a new charge, but for missing check-ins and owing over $3,600. It's a reminder that in court, even the small stuff adds up fast when you don't follow through. Over $3,600 in unpaid fees, And here's the reality. Courts don't accept "I forgot" as an excuse. It's not just about the missed check-ins or the money owed. It's about the pattern of behavior. Probation is the court saying, "We trust you to stay out of jail." But break that trust, and jail goes right back on the table. The system doesn't run on second chances. It runs on accountability.
Speak up, please. And did you plead true to those because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that we can have a sentencing hearing. I'll get probation to do an updated report. Looks like we probably will only need a probation officer, so we can do that on a normal day.
Yes,
Shouldn't take long. All right. And so you need to stop and talk to probation on your way out of the courtroom so that they can make sure and tell you what you need to do to get ready for that sentencing hearing, okay? All right, we'll see you back then. Good morning, ma'am. You're Dale Johnson, and Ms. Johnson is charged in 24 DCCR 1570 with indecency with a child by sexual contact, in 24 DCCR 1571 and 1572 with aggravated sexual assault of the child. And Mr. Johnson, what is the announcement?
Not ready, Your Honor. Our investigation continues. We have served subpoenas on 2 school districts. We're awaiting those records. I understand we're also awaiting some records from the Texas Department of Family and Protective Services.
Okay.
Agreed order of court signed.
Okay, that should be, that was signed back at the end of February, and I see your subpoenas. All right, so let's do this. I'm going to do maybe a 45-day reset instead of a 30. Hopefully we'll get somewhere on all of those documents, the CPS as well as what you've done, and see if we can get an announcement at that next court date. Make sure you stay in touch with Mr. Price. He'll let you know when you need to be back. All right, thank you. Good morning, you're Tyreek Flanagan, and this is cause number 23 DCCR 2310. Mr. Flanagan's charged with indecency with a child by sexual contact. What is the announcement?
Your Honor, we've gone back and forth with this quite some time.
We have.
I don't think we have any choice but to set it for trial.
Okay.
There's an issue with the outcry person. That was a CPS case in Harris County that was dismissed because of the source, and we've not been able, we tried to get that information. The state has tried through CPS, but we're not getting it. So we don't have much choice but to set this for trial.
I mean, I'll order it.
Well, that's the thing, Judge. We've done that, and we've reordered it.
I see that. We've done a second.
And what we're still getting back is the same set of records.
But it's not the records that show
With newer-
the dismissal
Right.
and why over in Harris
Do y'all
County.
want to do a very specific, try one more time with some,
And I talked with Kelly Friday. I was on the phone with Miss Adams, who's the regional attorney.
Right.
About, but we're getting another copy because our copy is gone. However, the newer stuff wouldn't have been in it. This is newer allegations that's happened since I've been on the case.
so are they going to work on getting that?
That's-
Did she say that?
I didn't get a specific, I'm still trying to get the original records. So we've sent this a second amended that I wrote specifically to get the newest, and it still didn't come back. So
Okay,
that was
but you
part of
talked
that.
to her and she knows.
That we're trying to, her assistant is getting me stuff. I'm in contact with her,
Okay,
but the newer stuff is the problem, dude.
right, but I don't want it to be. I'll call her, we'll call her. We've had no issues dealing
Right.
with her if we need something. So if y'all need me to do something, I want to get it done.
We just need to know the basis of the dismissal in Harris County. That's the same culprit.
Do a joint email to me today with the two of you guys and me saying what you need, and then I'll forward that and give Stephanie a call and see if we can find out what we need to actually get that specific information.
And I just want to let the court know, like, since I've been dealing with counsel on this, I've reached out to the Houston office, CPS, to find out if there's information that is get through that office as opposed to going to Austin.
Right.
The way we go. I've not gotten a response, or
Okay.
I've gotten turnover and all.
Send me something today, and then we'll try to, and before we put it on the trial docket, let's do one more reset. Let me reach out to Miss Adams,
Okay.
see if there's something she can do to help us with that Houston information.
Yeah.
And then there's got to be a way to get it. So I'll call whoever I need to call.
Thank you.
Okay. Stay in touch with Mr. Samuel. He'll let you know when you need to be back. Good morning. You're Ramadan Castillo? And Mr. Castillo is charged in each of his cases with aggravated sexual assault of a child. It's set for trial to begin with jury selection Monday, June 2nd. And what is the announcement?
Great. Thanks, sir.
All right. Well, obviously, it is one of the older cases. I anticipate it being at the top. We'll find out, I guess, actually next week, because we'll have a docket next Tuesday. But I anticipate it being up there. If anything happens between now and next Tuesday, let me know. There won't be any plea agreements after that. So if anything changes, y'all get together, and otherwise we'll try to get it taken care of on that day. All right. Stay in touch with Mr. West. He'll let you know when you need to be back. Mr. Mack, Mr. Mr. Kimler was here already. We called your name. You need to be here on time, okay? Otherwise, you're going to end up with a bond forfeiture and you'll be put in jail, and you don't want that to happen. So I'm going to recall the bond forfeiture. Your case is set for trial to begin in a couple of weeks. The attorney's announced ready. So I'm going to number the case for trial. You need to stay in touch with your bondsman and Mr. Kimler, and they'll let you know when you need to be back and ready for trial. It'll be in 2 weeks. Okay? You're free to go. Good morning. You're Rochelle Manuel?
Yes, ma'am.
And Miss Manuel's charged with aggravated assault causing serious bodily injury. What is the announcement?
Your Honor, she's been very good about staying in contact with me about updates and all that. We have a new plea offer that Mr. Nichols gave us today. She wants to accept that offer. She told me this 2 weeks ago that she's trying to be responsible. Her apartment lease expires this week and she gets her last check. And she's going to plead to pen time, and she wanted to wait to plead out next week if we could, so she could take care of her affairs. And I feel certain that she's going to plead.
Why don't we do that? Why don't y'all do the plea and I'll just reset it for sentencing, but we don't need to get a PSI. But that way we get that first part taken care of. And
I'll do that, Judge.
all right, I'll hold it while y'all do that. Mr. Elam, I'm going to have you tested this morning before we go forward. Have a seat in the jury box. Let's see if you got anything in the system. Good morning, sir. Are you Nicholas Gilmore Jones? And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Jones, in cause number 24, DCCR 1441, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to